All right, good afternoon, everybody. I'm Judge Mariam Ahmed. I preside in the post-judgment and miscellaneous remedies call in courtroom 1401 of the Daly Center. Today, I'd like to talk about some of the basics of post-judgment litigation. So if you're a more seasoned post-judgment attorney, some of this may be redundant, but for those of you who don't practice in this area often, or have very limited post-judgment experience, this workshop, I'm hoping, will give you a good fundamental understanding of post-judgment litigation. Before I begin, I just want to explain, because so many attorneys practice throughout Cook County, not just in the city of Chicago. Some of you practice in suburban Cook County. Others of you may practice in other county jurisdictions in the state of Illinois. And so with that in mind, the focus of this workshop will not be on the procedures of courtroom 1401. I'm going to talk about the post-judgment tools available in general under Illinois law. The finer points of litigation will sometimes vary from judge to judge, but even with those finer points, the law remains the same, the statute remains the same, regardless of what jurisdiction you're presiding in. For those of us in the post-judgment world, 735 ILCS 5/2.1402, fondly known as Section 1402 by those of us who practice in this area, is the controlling statute. It is the statute by which we all live and breathe in post-judgment litigation. And before I go through some of the post-judgment tools, I'm going to focus a little bit of the discussion on 21402. Additionally, I want to provide you with, in the materials, a link to the approved statewide forms for Illinois post-judgment litigation. Let me explain why I gave you this form link up front and at the beginning of the materials. Post-judgment litigation, by its nature, is actually designed to be more streamlined. Why is that? It's because you've already litigated pre-judgment and secured a judgment. And so the court and the law doesn't expect you to engage in the full-throated type of litigation that occurs pre-judgment. And so you'll find in this area of litigation, there are a lot of template forms already created. That is to keep attorneys from, one, reinventing the wheel, but it's also designed to minimize your costs. And you're going to hear me bring this up probably at several points during the CLE. In post-judgment litigation, you're mindful of the economics of litigation. And by the economics of litigation, what I'm referring to is the costs involved in litigation. Your client, if you are representing a creditor, has already litigated and received a judgment that is unpaid. And so for that client is not looking to continue to expend unnecessary resources. And so the reason there are so many forms, boilerplate types of forms, is to keep you from having to go back and redraft all of these documents, all of these pleadings over and over again. You can use a set group of forms that is accepted by every Illinois court. And so when attorneys come before me, I'm always referring attorneys to these standardized forms. Just about every boilerplate form that you need in post-judgment litigation is available on this website. That's why it's there and up front. Here's what I'd like to do today. I'd like to talk about 50 minutes or so on the basics of post-judgment litigation. I'd like to reserve about 10 minutes toward the end to address any questions that you might have, whether it's questions regarding the law, procedures. For those of you who might have questions about aspects of litigation in Courtroom 1401, I'm happy to answer those questions. I'd like to provide an overview of the main tools used in post-judgment litigation. There are many, and finer minds than me could spend hours going through every aspect of post-judgment litigation. I don't have hours, you don't either, so I'm just going to cover the basics. And again, as I indicated, I'm not focusing the conversation on my courtroom, Courtroom 1401, but just going through the tools in general that one would use and that are authorized by statute in the state of Illinois. When do post-judgment proceedings begin? Post-judgment proceedings begin when you are in front of the civil trial judge and you receive a final and appealable order, or you receive a final judgment, and that judgment after 30 days is still unsatisfied. Post-judgment litigation can proceed after a party, a creditor, has registered a foreign judgment. I'd like to talk a little bit about that aspect. So in my courtroom and in many others, it is not uncommon for creditors to bring forth judgments from other jurisdictions. The process to register the foreign judgment, at least for here in the first district, does not begin in this courtroom. It happens before a case comes to this courtroom. So through the Circuit Court of Cook County, a foreign judgment is actually registered through the clerk of the circuit court. And then how do you know your judgment is registered? Once they sign off on that form and give you, if you're trying to register that judgment in the first municipal district, when they give you that first municipal district case number, or if you're trying to register that judgment to be heard in Cook County, but in Skokie, when they give you that second district municipal case number. As soon as you get that case number, you are free to litigate. So here is a mistake that I see some attorneys committing. What they'll do is have the registered judgment, but then file a motion with me to re-register, or basically submit another judgment order to me to enter it after you've received a registration of foreign judgment. It's a duplicitous process. This court does not award judgments. It enforces judgments. Again, this court does not award judgments. It enforces judgments. So once you receive that case number, you don't need my permission. You don't need the post-judgment court's permission. You're now free to go and do whatever post-judgment litigation you wish to proceed on. You just have to go through that step of registering that judgment through the clerk of the circuit court. And Clerk Spiropoulos, like me, is a believer in forms and has a form process that you do. And she lists out all the documents that are necessary on her website as to how to register a foreign judgment, be that a City of Chicago judgment or a judgment from the state of Philadelphia. Okay. So once you have that registration, you're free to conduct post-judgment registration or post-judgment enforcement. The other time one can proceed on a post-judgment case is if you have a dormant judgment, meaning you receive the judgment from the circuit court, 7 years have elapsed, you haven't done anything with the judgment, either through just not having an opportunity or litigation strategy. Your strategy was to sit on that judgment to wait for the debtor to amass resources and then come back and enforce that judgment. So if your judgment is dormant and you revive it successfully, then you are free to engage in the enforcement of the judgment under 214.02. And I'm going to talk a little bit more about revival later, but this is when the post-judgment process begins.
A judge granted an eviction for one of my apartments. The tenants hadn't paid.
Let me make sure this audio is loud so you can hear this. Okay.
So in addition to the eviction, the judge awarded the back rent, granted an eviction for one of my apartments. The tenants hadn't paid rent in 8 months. So in addition to the eviction, the judge awarded the back rent plus court costs. The back rent was for 8 months and totaled $16,000. The court costs were $1,500 and the total judgment was for $17,500. It's been 2 months since the judge entered the judgment, and the defendants haven't paid me. I just want my money.
So, as you all know, as seasoned attorneys, the judgment is not particularly helpful if you're unable to enforce it, if you're unable to obtain the funds from the judgment. And so that's where 214.02 comes in. So I'm not going to go through every aspect of 214.02, but there are some salient points I'd like to point out. In terms of 214.02, it's under the Illinois Code of Civil Procedure. It governs all supplementary proceedings, and it enables creditors to collect unpaid judgments for non-exempt assets and income through citations. So non-exempt assets, not all assets. The next salient part regarding 214.02 is that it creates a lien on assets. 214.02, upon service of a citation, be that a citation to debt or a third-party citation, establishes that lien on the debtor's non-exempt personal property, which also includes any third parties that debtor may have transferred assets to. What's most important in terms of the lien that 214.02 creates is that it brings not only the debtor, but if you're serving a third-party citation, it brings the third party under the jurisdiction of the court. And it keeps the debtor under the jurisdiction of the court. The lien is perfected upon service of the citation, and I want to explain a little bit more about this. Under 214.02, once you issue a citation, and I'm again just speaking issuing it, you send out the citation. It is still in what is called the default period until it is actively served. It is the service of the citation that activates the citation. So if a creditor attempts to serve a citation, and this is a citation to debtor, and it is unsuccessfully served, you're still in that limbo period until that citation has been successfully served. And when you issue a citation to a debtor, it must be personally served. 214.02 also creates a restraining order upon the successful service of the citation. It prevents the transfer of assets between the debtor and other parties, third parties. If the debtor actually violates the citation prohibition for transferring personal property, it can also open that debtor up to sanctions. The same is true when a third party is issued a citation. So another benefit of the citation is the restraining provisions that remain in effect as long as that citation is in effect until further order of court. 214.02 also gives turnover authority. Where third parties retain assets that belong to the debtor, not only does it create the lien, not only does it restrain the unlawful transfer of those assets, it gives the court authority, whether it's over the debtor or the third party, to then transfer any non-exempt personal assets to the debtor. I want to explain something about the importance of a citation and turnover authority. Periodically, I've seen situations where a creditor will send me a turnover order, and it'll be directing, for example, a third party to turn over assets to the judgment creditor. Well, the first thing the court's going to do is to look to see whether there is a citation that was served. One, notifying that third party of the potential of assets belonging to the debtor. Two, determining whether that third party responded to either an interrogatory or responded to any type of notice indicating that they do actively possess assets belonging to the debtor. And then the other thing is to ensure that the court has jurisdiction. And so if a party sends the court a turnover order and there's no citation in place, the court has no authority to order a third party to turn over assets, even if the creditor strongly believes those assets, that third party has assets that belong to the debtor. So it's important when a creditor identifies assets to make sure that a citation and interrogatory is sent to that third party. So 214.01 gives turnover authority, but only over those matters where there is a properly served and noticed citation. I also want to point out the governing provisions. 735 ILCS 5/12-801 provides exemptions for third-party citations that are served on employers. I keep using the phrase orders the turnover of non-exempt. Citations restrain non-exempt wages or bank funds or other monies. That is because certain types of financial instruments, money, funds, assets, are not collectible under 214.02 and under 1218.01. So 1218.01 deals with third-party citations sent to employers for wage garnishment. It tells you, for example, certain types of wages are not subject to collection. Social Security. There are a number of other forms of wages that are not collectible. Similarly, 214.02 identifies those exemptions for bank citations, non-wage garnishments, such as bank citations. There's a whole list of exemptions. Two 214.02 also provides supplemental authority to courts and to the parties. Illinois Supreme Court Rule 277 also provides guidance to attorneys in terms of the various hearings that are conducted post-judgment regarding notice and the circumstances under which hearings can occur. 21402 and Illinois Supreme Court Rule 277 also authorize contempt of court sanctions for failing to appear on a properly completed and served citation, for failing to comply with document production requests, for unlawful transfers, meaning violating liens, restraining provisions, and unlawfully transferring assets. Let me give you a real world example of when you would utilize the contempt of court process. Remember, Illinois is not we don't have debtor's court in Illinois. So you're not pursuing contempt because the debtor failed to pay the lower court judge's or the trial court judge's order. That's not what you're pursuing contempt for. You've issued, for example, and properly noticed, properly completed, and personally served a citation to debtor, ordering that debtor to appear in court. The citation to debtor is the document that you use as a discovery tool. You're using it to discover that debtor's assets and also that debtor's liabilities in order to determine that debtor's ability to pay the judgment or not. To pay the judgment or not. On the court date, the debtor fails to appear. Then, if your litigation strategy after consulting with your client is to pursue contempt of court, then you are free to ask the court for an order potentially holding that debtor in contempt of court. And so you're going to begin the sanction process. If the court agrees that your documents are in order, the debtor should have appeared, and grants you an opportunity to issue a rule, and you issue the rule explaining to the debtor the consequences of failing to appear, to either explain to the judge why they didn't appear on the served citation, or fail to complete documents if they were asked to return to complete documents and failed to do that. Once you personally serve that rule and the debtor still fails to appear, to either participate in the citation exam or to tender documents that you've requested from that debtor, then you can ask the court for additional sanctions. The sanctions could be a body attachment, but you have to go through the steps of holding that debtor accountable for the failure to either appear and answer the questions or complete documents. It is not contempt of court for failing to pay. Separately, you learn that the debtor has transferred a lot of assets to another party, a third party. You can ask for a hearing on contempt of court for that. And something like that would be set for a more substantial hearing for you to present to the court your evidence. The debtor would have an opportunity to appear for such a hearing to answer. If the court is satisfied after a hearing that the debtor did unlawfully transfer assets, the court may issue sanctions. Or if the debtor fails to appear at all to explain this potential transfer, unlawful transfer of assets, that enables you to pursue contempt of court. So Illinois Supreme Court Rule 277 gives the direction and the guidance for the punitive aspects of failing to comply with Section 214.02. So I began already by talking about citations to discover assets and third-party citations. I want to talk a little bit more in detail before I move on. It's really important, if you practice post-judgment, to have an understanding of what these tools are. I think on a daily basis, I interact with attorneys and I can tell the attorney doesn't understand. And this isn't the seasoned attorneys, because I have many attorneys who are very seasoned and do this work all day, every day. But for those who are relatively new to post-judgment, I can pretty quickly spot an attorney that doesn't understand the tools. And so if you do not have any idea of a debtor's assets and liabilities, the citation to the debtor is the discovery tool that you want to use to bring that debtor in so that they can be placed under oath, and you can ask them questions about their assets and liabilities, finances, property, whatever you want to ask related to their finances. Now, I'm going to give you a for example. For example, if in that video that I played, the person stated that he owned properties and he received a judgment pursuant to an eviction. Many of you who practice in evictions, your client has the financial information already. Your client knows where the debtor banks. Your client knows where the debtor works, generally because they took in that information when they were making a decision to rent to them in the first place. So it is actually not uncommon for some creditors to never come into court. Because for me, when you're coming into court physically on Zoom, you're coming in to conduct a citation exam. There are many attorneys who conduct their practices pretty much 90% outside of the courtroom. I've presided in 1401 for nearly 2 years, and there is probably about 25% of the attorneys who appear before me regularly who I have never seen. And that is because they have all of the financial information. When they receive the judgment, they already have the financial information. So they are using a different tool post-judgment. They are using third-party citations. A third-party citation is a citation, again, to restrain, to place a lien on personal property belonging to the debtor that's in a third party's control. That third party can be a bank, it can be a credit union, it can be an employer. I've seen trust funds, I've seen other different types of financial entities that hold funds for debtors. You're sending them a citation because you know of their existence already. And you might know that third party, I know, has enough money to satisfy this judgment, particularly in situations where you don't you don't have the judgment isn't extraordinary for an extraordinary amount. So if you have the bank information or the employment information, that might be sufficient. Why is that important as a tool? Because again, the economics of litigation, it keeps the attorney from going through the effort of filing, serving, and all the time involved in that to bring a debtor into court, and the rate that you charge to conduct that citation, you may not get them there the first time. So you're looking at multiple trips to court, multiple potential exams to get the same information you already had. And so there's a strategy to this post-judgment litigation. That citation to the debtor is the tool that you use when you don't know anything or you don't know enough. But if you have enough with the bank accounts and you know they're active and viable, or the employment information or other financial entities that debtor is associated with, you don't need the citation to debtor. You send your third-party citation and you keep your litigation moving. You've streamlined your costs and you've created a way to place a lien and a restraining order on that third party to keep them from disposing of that funds. And then you can, once you provide your supporting documents to the court, can then ask the court for a turnover order. I don't need to see you to enter a turnover order. I just need to see your documents. I just need to see they were completed properly, served properly, and that your notices were correct. If I see that, I'm going to grant your turnover order. Why? Because 21402 says I have to if it's non if it's non-exempt personal property. 214.02 doesn't say, well, Judge, if you think that the person shouldn't get the money, you're going to use your discretion and deny that. No, there's no discretion in this. It is pretty clear. It's either non-exempt property or exempt. If it's exempt, you can't have it. Statute lays out all of the categories where those funds and property is exempt. Sorry, counsel, you can't have that. You've looked at 214.02, so you know not to ask because you know it's in the statute. It's really clear what you can have and what you can't. But if it's non-exempt, then you're going to proceed. Now, this is another misapprehension I see. An attorney will say, well, I'll say to an attorney, Mr. Jones, has Mr. Jones complied with the citation? You conducted your exam? Yes, Judge, I did. Great. Did you receive all the financial information you needed? Have you had a chance to follow up and verify it all? Yes, I have. Did Mr. Jones comply with your document requirements? Did he provide you all the documents you were seeking? Yes, Judge, he did. Great. Has he satisfied everything that you wanted? Yes, he has. Well, are you going to dismiss or discharge the citation to debtor? Well, Judge, I don't want to do that because I have a third-party citation outstanding. That's someone who doesn't understand the tools. Citation to debtor is a third-party citation is not predicated upon the existence of a citation to debtor. Let me make that a little more clear. One has nothing to do with the other. These are different tools. And so, again, the point of the citation to debtor is a discovery tool for you to get the information from the debtor. Once you have that, that's it. You don't keep bringing the debtor back to court. Periodically, an attorney will say, well, I don't want to discharge citation. I'd like the debtor to come back for status. Status on what? Well, I'm going to file these third-party citations. No, that's not the purpose of the citation to debtor. It's not a leash to continue to pull the debtor to court. It is just for you to collect your information. That's it. To enable you to then go off on your own and send out your third-party citations. They are not connected. And except for the information you get helps you do that. But you don't need to have the defendant or the debtor coming along every time to collect on a third party. All right. So that's something important I want attorneys to understand. Once you have your information, you're free to go out and issue those third-party citations. Now, let's say you dismiss the citation without prejudice, because you never know when some assets may pop up, and indeed they do. You find out that there was some misinformation, or you learn 6 months, 7 months later, there's some new potential assets. You see the debtor, in fact, on the news with one of those big checks, and it says, Illinois State Lottery, and you recognize that that's the person you did the citation exam, and you're saying, whoa, this person has some additional resources. Are you without options? No, 214.02 says you can seek leave of court, Judge. I just learned on information and belief. Here's my information. Look at this picture. Here's my belief. Here's his name. Here's his address. He just received this big old check from the Illinois State Lottery. I'd like to bring him back in for a citation exam. We seek leave to file an additional citation to debtor. All right, leave will be granted, because you've established that there are likely some additional resources. So remembering dismissing or discharging the citation doesn't prevent you from revisiting assets if you learn of the existence of assets further down the line. Okay. All right, another video.
I emailed the judge that I wanted to have a hearing about the wage garnishment. I don't make enough to have my wages garnished. I'm in school. I am the sole supporter of my family, and I already have more bills than money. The debt is $20,000. I'll pay it when I have money. They don't need to garnish my wages. I emailed the judge.
So I talked about exemptions. Be prepared for exemptions. Certain funds are exempt under the statute. You're looking for non-exempt personal property. But I also want you to be aware of non-defenses. So as I indicated, 214.02 is very clear. It says non-exempt personal property. Wages is personal property. The non-exempt portion is the amount that is not subject to any statutory exemption. And so 214.02 tells you the percentage that you can seek from a person's wages. And the court has no discretion to alter the statutory formula, to amend the formula. If those assets exist, they must be turned over. And so if I hear, and I do often, a lot of reasons as to why a debtor believes they are unable to have their wages garnished from a third-party citation. Those are not viable defenses under 214.02. Now, here's what you need to know about exemptions. In addition to some of the main ones, Social Security, certain types of medical benefits, Illinois Supreme Court Rule 288. Illinois Supreme Court Rule 288 impacts judgments that are small claims judgments, $10,000 and under. Rule 288 indicates that a debtor can seek a lower garnishment deduction if it's a small claims judgment. And so periodically, a debtor will contact the court and ask the court for a Rule 288 order. Rule 288, again, specifically is for small claims judgments. If it's a judgment over $10,000, then it doesn't qualify. So if it's $17,000 and it's based on damages that a debtor was ordered to pay because they allegedly battered someone, and the court entered judgment in favor of the plaintiff for, let's say, $17,000, or it was one of these judgments where it started out as a replevin, it went to judgment, the vehicle, the remaining judgment or amount of the vehicle was like $15,000, something like that, and it was converted into a judgment. Those types of judgments are not eligible for a Rule 288 order. A Rule 288 order, the court cannot dictate how much a party should pay for Rule 288. What Rule 288 says is small claims, and it has to be a monthly amount that will enable the judgment to be paid off within 3 years. So if a debtor proposes an amount that will extend repayment beyond 3 years, that doesn't comport with Rule 288. And so I can't speak to how other judges handle that, but here in the first district, what we do is have the attorney and debtor speak and work out between themselves the amount that the creditor's client, the creditor attorney's client, is willing to accept, compared with how much the debtor believes he or she can pay. And it still has to fulfill the requirements of Rule 288, meaning it has to be an amount that can be paid within 3 years of the order being entered. So just be aware of that. It's not an exemption, but it is a rule that impacts wage garnishment orders in small claims judgments. now. Okay. I want to make sure you can see this entire screen. So I want to talk a little bit about revivals of judgment. And on this slide, I've actually provided some detailed information, and it's because revivals can be tricky. There are different rules for different types of judgments. So I want you to know that section 216.2 and 13-2.8 cover the statutory frameworks for the different types of revivals. And if you're someone who handles these matters periodically, you really do have to do a close read of the statute to make sure that your revival is timely. And I won't go through word for word these statutes, but I do want to make you aware of them. So once a creditor, so 7 years have passed and you're at year 7 after the judgment was entered, no action has been taken on the judgment. It is in default and it is dormant. That judgment must be revived under certain circumstances. If I had conducted this presentation a year ago, I would have left it at that judgment must be revived. I'm now adding the caveat under certain circumstances because there was a new change in the law in 2026 that I'm about to go through that shows you that there's been some more wrenches thrown into the revival calculus. It was complicated before. It gets a little more complicated because there are now more rules. But essentially, you have a judgment in default that is dormant. You file your petition to revive. Proper service is required for a revival. 214.02 directs you to Supreme Court Rule 106, which immediately directs you for revivals to Illinois Supreme Court Rule 105, parties in default. And essentially what it says is that service occurs in the manner of summons. Summons prejudgment occurs with the service of the summons by personal service. Revivals have to be personally served. I've had so many discussions with attorneys about this fact. Revivals are supposed to be personally served. The statutory timeframes differ according to the type of judgment. There are 4 defenses I want you to be made aware of to a revival. Defense number 1, debtor says no judgment was ever entered. I've never received a judgment in this case. That's one defense. 2, the debtor was not served with the petition to revive. And all of these are followed, these allegations are followed by a hearing. These are not matters that are handled outside of ex parte or by motion where you don't file a brief and are appearing for a hearing. The judgment was paid or otherwise discharged in bankruptcy. And the revival action is untimely, meaning that the creditor missed the statutory time frame by which to pursue the revival. You were late in converting your dormant judgment and late in trying to revive your dormant judgment. So those are the defenses. There are limitations on the challenges. A lot of folks, a lot of debtors like to attempt to relitigate the underlying judgment in a revival hearing. You can't do that. So the validity or merits of the underlying judgment cannot be contested in a revival proceeding. It is specifically focused on one of these defenses. A challenge to the underlying judgment must be filed in the court where the judgment was entered. So if the judgment came from the state of Pennsylvania and you're timely reviving it, the debtor can't say, well, Judge, I want to have a hearing on this judgment. I wasn't properly served on the underlying judgment. No, that is not an issue for a revival hearing. The question is the revival itself. A challenge to the underlying judgment, if your issue is, I wasn't properly served before the court in Pennsylvania, okay, you have to go back there and mount that challenge. The revival continues. The post-judgment action continues. Challenges to the underlying judgment do not stop post-judgment proceedings. If the judgment came from the city of Chicago, I want to contest it, Judge. You're trying to revive. I'm saying it shouldn't be revived because there was a problem with the underlying judgment. The amount is wrong, or those allegations were wrong, or I didn't know about it. Those are not defenses, viable defenses to a revival. So there were no fewer than 9 or so different amendments. I think there were a few more, might have been closer to 12 amendments, 2026 amendments to the Illinois Code of Civil Procedure. And some of those amendments affect post-judgment proceedings. And I just wanted to bring several of them to your attention, just so you know to go back and take a look at the 2026 version of the statute. So the citation to discover assets now have to have additional warnings. And the forms on the Supreme Court site have those additional warnings. So one of the warnings is if a judgment is a consumer debt judgment, it has to be stated as such in the citation certification. So the cover sheet of the citation, where the information is given regarding the judgment amount, and the citation cover sheet has some background information that the creditor provides regarding the judgment. There's supposed to be language in that document now, as of January 1st, notifying that debtor that this is specifically a consumer judgment debt. The citation notices have to include additional warnings and updated exemptions. So some of the exemptions were updated as well. I don't list them all out. Some I do on some subsequent slides, but not all of them are listed. You have to go back and check those. So here's another big difference. The Citation Act is amended to include an automatic exemption of $1,000 in the defendant's property held by a third party. Okay, so let's talk about this. So those of you who've done some post-judgment work, you know with bank citations that there's a $4,000 automatic personal exemption per judgment. And let me say this again for those who are relatively new to post-judgment. If I serve a citation on JP Morgan Chase Bank, if the debtor requests a personal exemption and that account has under $4,000, they are entitled to an exemption, meaning that money can't be touched, up to $4,000. That's the previous statute. If I don't contest the bank citation or ask for the personal exemption, then all of the funds can be turned over, even if it's $50 in my bank account. So if I request a personal exemption, it's $4,000, but it's not $4,000, everyone, per citation. It's $4,000 per judgment. So if I have an old judgment that has been successfully revived by the attorney a couple of times, and let's say the case started, just for numbers' sake, in 2010, and a third-party citation was sent to Chase Bank that had $1,000 in the account, and the debtor requested a personal exemption and was granted it for that $1,000. That means there's $3,000 left as to that judgment. Okay, so it's not $4,000 per judgment, it's or per citation, it's per judgment. And you have to be mindful of those prior exemptions. One of the things that I do when I'm reviewing bank citations, particularly on older cases, is I have to go back and look at every single third-party citation that was issued and if there were prior exemptions awarded, and do the math and add all of those up. And I will at least make the creditor's attorney aware, hey, when I reviewed the case file, I saw these prior exemptions. This is the total that I've seen granted thus far in exemptions. You look, you do the math. But if there, by my math, there is $1,000 left for personal exemption. You check 2 and see. So again, you have to be mindful of the case history with these exemptions. Now, I just said, under the new law, there's a $1,000 automatic exemption for defendant's property held by a third party. So I said subtly, if a debtor requests a personal exemption, they are granted that amount. But if they don't, even if it's $50, it goes to the creditor, not anymore. So if it's $50 in that account, even if they didn't ask for the personal exemption, under this new law, they get up to $1,000, everybody, automatically. So I shouldn't be seeing turnover orders with, $50, $75, $100, like we used to because of this new law. So just be mindful of that. Okay. I comment that sometimes when these statutes change, it's almost like these provisions are whispered into law. And so it really shows that literally every year you have to go back and read relevant statutes when you practice in a certain area substantially, so that you're aware of these subtle changes. There have been some changes to the revival statute. I mentioned that. I wrote it out, and I'm going to need to read it to you because it's detailed. Revival of judgments is amended for consumer debt judgments. The statute of limitations for filing a petition on a consumer debt judgment prior to January 1st, 2020 remains 20 years. Judgments entered between January 1st, 2020 and January 1st, 2026 may be revived once within 10 years. Consumer debt judgments entered after January 1st, 2026 will be enforceable for 15 years and no revival allowed. 15 years, everybody, and no revival is allowed. So you're not going to be able to let that go dormant because you're not going to be able to revive it after January 1st, 2026. Judgment revival for non-consumer debt judgments are not affected by the new law. So again, the focus is on these consumer debt judgments. You're all going to have to go back and reread the revival statute in detail if your practice involves revivals of judgment. All right, non-wage garnishments, bank garnishments, the types of third-party citations you send to financial institutions. Those forms are going to be updated with an additional certification and the updated exemption. So there are going to be some changes to the standard forms. Another change, all household goods are exempt from levy and sale unless resale value is more than $5,000 and the court gives permission for sale. So that watch, that's a nice watch that you were thinking you would request, that's worth $3,000. You can't have it anymore because the value has to now be over $5,000. That vehicle, the Honda, with all the bells and whistles, if it's not valued over $5,000, it's exempt. Okay. I mentioned earlier that there are some additional exemptions. So various property exemptions are increased. So the homestead exemption is now $50,000 for an individual jointly owned property, 100,000 for co-owned property. Motor vehicles, the exemption is now $3,600. Tools and trade, so you're sending a citation to a business that owns tools that belong to the debtor, machinery, that kind of thing. They get a $2,250 exemption in tools. Bodily injury awards are exempted up to $22,500. So the award has to be over that. New automatic exemption, I already mentioned that, $1,000 as part of the $4,000 personal property exemption. So it's not $5,000, it's $1,000 automatic and then the $3,000 on top. $1,000 automatic even if they don't ask for it. And then the additional exemptions are listed under section 12-1001 for more information. So here's some practice pointers. Make sure that you're confirming that there is actually a valid judgment before you file anything post-judgment. You want to make sure that your service process is correct, that your notices are correct. And remember, your notices and type of service requirements vary according to the type of citation you have. Citations to debtor or serve personal service, third-party citations, certified mail, with the debtor having to receive a copy of everything via U.S. mail 3 days after. That hasn't changed. Use the appropriate enforcement tool. I've already gone into detail about that. But here's what I want to tell you. Don't guess at assets. And I want to tell you what I mean by this. So one of the ways a creditor can raise the ire of the court and subject him or herself to sanctions is by sending out third-party citations to banks where you're not really certain if the person has an account, but you say to yourself, just about everybody has an account at Chase Bank. If they don't have it at Chase Bank, they have one at Fifth National Bank. They might have one, they live in this suburb, so they probably bank at Huntington. I'm gonna send some citations over to these banks. Yeah, don't do that. You need to serve citations with assurance. If you don't know, bring the debtor in for an exam. But again, that's the fastest way to raise the ire of the court because you may be unwittingly placing a hold on somebody else's bank account. And the reason I mention it is because regrettably, I have seen that happen. All right. Make sure you are providing the appropriate notice to debtors. It's not enough to send third-party citations to the entity. Whatever you send to the third party, 3 days later via U.S. mail, you have to send that packet to the debtor. And you have to make sure that the debtor is aware that they may be able to claim exemptions and that they have a right to request a hearing for just about everything. Just because a debtor requests a hearing doesn't mean there's a legal basis for it, but they need to know that those rights exist. So notice requirements are strictly enforced by the courts. And now your questions, and hopefully I will have answers for you.
Okay, thank you so much. We do have 3 questions. The first one is, are there any plans for statewide third-party citation forms or bringing back the Cook County forms?
They are on they should be in that that link that I provided on page 1. Those are for the statewide forms. So the Cook County forms on Clerk Sparopoulos' website. That wasn't Clerk Sparopoulos' website. That was the Supreme Court's website on page 1 of the slide, or page 2 of the slide.
Okay, thank you. And
please question. Use those forms. Some of you create such beautiful forms. You do. But the problem is when you sometimes create your own forms, you may leave off pivotal information. The reason the Supreme Court created these forms is because it has all the information you need. You don't have to worry about reinventing the wheel and carving the wheel incorrectly. So you feel free to use these forms. Go ahead.
So we have another follow-up to the question from the questioner, William Cohn. Says he's referring to non-bank, non-employer, third-party citation forms.
Yes. You know what? I don't really see the Supreme Court doing those because those types of forms are real specific to an entity and do actually require some workmanship, right? So, but what I would recommend is that the basic language you get from the form orders, but then go ahead and tailor those to your specific needs. So like, for example, like if you were sending a third-party citation to some trust that you want to create and craft. So there's no form orders for the higher level assets, but feel free to use these form orders as a starting point for those.
Okay, we've got another question here. Where does section 21402 say you have to wait 30 days after the entry of a final judgment to issue a citation?
I would have to pull it up.
Okay.
Yeah, I know I probably seem like I have everything memorized, but I don't.
You do. You've been amazing. And then final question that we have here is, does the court permit an in-person examination of the judgment debtor in the plaintiff's attorney's office or other place rather than remotely?
So I can only speak for myself. I do. So if you tell me, I'll say, if you say, Judge, we want to schedule a citation exam, do you plan to use the court's resources, Zoom, or your own office or another location? And if you tell me my own office or another location, I'm fine with that. I just tell you, okay, go ahead and do it. And then just let's schedule a status date so you can report whether or not the debtor has complied with the citation requirements. I don't know what other judges do.
Thank you. We have another question here. Please discuss lien of garnishments versus continuing lien of citation when attempting to collect from third parties.
So I believe you're referring to, and correct me if I'm wrong, are you referring to in terms of the lien of garnishment where you're doing, for example, a third party citation to an employer and that lien remains as to that garnishment until the judgment is paid?
Ronald, if you want to unmute yourself.
No, what I'm referring to is let's use a bank garnishment, for example.
Okay.
A garnishment to a bank to collect from an account versus serving them a citation. And what I'm specifically driving at is funds deposited subsequent to service of either the garnishment or the citation after acquired assets, if you will.
So what I've seen is, one, you still need to do the citation to that bank for all of the reasons that 21402 require. But if that is an account that you know that additional funds might be deposited into, you can say specifically in your order that any additional funds must be turned over. So in that sense, you are keeping that lien active for that citation.
How about funds deposited in the gap period, meaning after services citation, but before a turnover order is entered? So I serve the citation, there's no money, but before I get before Your Honor for a turnover order, a check for $10,000 is now in the account.
That money must be held. It's upon the service of that citation that lien takes effect. And
understood.
So I've seen, that's actually a really good question because I've seen it happen with entities where money was permitted to be transferred and the creditor brought them in on a contempt hearing. It will bring a party in on a contempt hearing because of the unlawful transfer. That's an allegation of an unlawful transfer. And so under those circumstances, the question to that third party would be, well, why did you transfer those funds? Because there was a lien in place with the citation. And you all know the citation document itself spells out that there's the lien, that this is a restraining order, and that you are prohibited from transferring assets. So no, that is not supposed to occur during the gap period, which is actually not a gap period because that citation has been served.
Understood. Thank you.
Very good question.
Thank you. Well, that is it for our questions.
So there's some resources. I'm a former professor, and I believe in providing resources. So there are two resources I want to make you all aware of. The first is the Illinois Creditors Bar Association, for those of you who practice in this area. And I'm going to tell you why I'm giving you this as a resource. My own practice background involves a lot of work with different bar associations. And I believe in the community of lawyers and lawyers working together to help each other, particularly in some of these more specialized area. We come from an apprentice type of profession. And so the Illinois Creditors Bar Association is a group of creditor attorneys that I prevail upon when I see new attorneys struggling in this area. So I want to make you aware of this resource so that you all know that there are other attorneys out here who do this work and who are interested in a fellowship. I do not work for them. I am not a member, but I do believe in passing on really good information and helpful information. For those of you who litigate in courtroom 1401, specifically here at the Daily Center, I have created a YouTube channel for litigating in courtroom 1401. I have videos that I have created specifically that cover various aspects of post-judgment litigation in courtroom 1401. Listen, I know a lot of you rely upon legal assistance and paralegals to prepare your documents for you. Again, I am mindful of the cost of litigation, and I want to create an environment where if it's you or your personnel can put together these documents and forms in a way that's where it's done correctly the first time. I don't want you to have to go through a lot of trial and error. That's why the Supreme Court and the Circuit Court have forms for you to use. And so I provide, again, videos that take you through. If you know how to bake a cake, a person can follow these types of videos because it's step-by-step information on how to complete documents, how to serve them properly, that kind of thing. So I hope you feel free to take advantage of these resources, and I hope they help you conduct your law practice in a real efficient way. Thank you for tuning in today and for listening and for your patience and your attention. I appreciate it.
Thank you very much. It was a wonderful presentation. There's many kudos for you in the chat if you want to look at them. And I didn't, because we started late and I didn't take time to thank Judge Deborah Gubin for putting together this class for us, for recruiting our speaker. And Judge Ahmad, there's requests for you to do another one. So we're going to be back in touch with you to do one for next year as well. Thank you so much.
Sounds good. Everybody stay warm tomorrow.
Thank you. And for the attendees, I'm just going to put up the survey so that you can give your feedback for this class. And thank you all very much for coming in. Also, while you're doing that, I'm going to go through all of the classes that we have coming in.